Yeah! You know who it is. Hey, don't ask who did it. Check the name, fool. The associates did it, yeah, they rolling deep. The associates did it.
Good morning, and welcome to yet another episode of the Associates Did It podcast. My name is Josh Carpenter. I'm an attorney with Carpenter & Associates law firm here in Dallas, Texas. And I am the host, narrator, writer, and pretty much everything for this little thing. But of course, it is produced by the amazing Todd Cohen. And so today we are talking about the top 10 things to not do if you want to win your case, or top 10 things to do to lose your case. And so we've actually gotten through 6 of the 10 already in the first episode. So this is a continuation of that. So if you haven't listened to the first episode on this little series, you might want to, else you might be a little bit lost. Otherwise, stick around just for the fun. All right, I'm just going to hop in. I don't really have any ground shaking news or anything else like that. And so I am going to hop in, and I believe we are on step 7 on what to do to lose your case. All right, so you remember Bobby? He was the quintessential moron, and he kept doing everything against his lawyer's advice, and then getting online and trying to give his lawyer ChatGPT and Google and other information that was almost completely wrong all the time. I'm sorry to yawn in your ear there, but it is early. And so, at any rate, so step 7 is going to be treat the deposition like a podcast, which is fun since we're doing a podcast. So, step 7 is to view your deposition and or discovery, but we're just using deposition for sake of ease. Use it as an opportunity to tell your entire life story. A deposition is a sworn testimony taken before trial. It's used for purposes of possible impeachment at trial, but the real purpose is to basically just ascertain what facts and what is actually going on in the background of the case. So the opposing lawyer will ask you questions. A court reporter records the answers. A transcript may be used in motions, hearings, negotiations, and of course trial. I'm sorry to keep yawning in your ears. The goal is to listen carefully and answer truthfully if you are the witness. Now, that obviously sounds simple, but it is not simple for Bobby. Nothing in this case is simple for Bobby. Before the deposition, Bobby's attorney gives him instructions, and he says, Bobby, for the love of everything good and holy, listen to the entire question. Bobby nods. Pause before answering. Bobby nods. Answer only the question asked. Bobby nods. And Bobby, if you don't know the answer to the question, say you do not know. Don't guess. Don't argue. Listen to the question, pause, and answer honestly, truthfully. And if you don't know, say you don't know. Got it? Bobby says, I've got it, buddy. All right. Let's go start this deposition. 5 minutes into the deposition, opposing counsel asks, please state your full name. And Bobby responds, well, before I do that, I think people need to understand how this partnership started. And it keeps going from there. Later in the deposition, Bobby, did you sign this contract? What exactly do you mean by sign? Is that your signature? It resembles my signature. Did you write it? I read a lot of things. Did you place your name on that document, Bobby? I may have. Is there a reason you cannot answer yes or no? I don't like being boxed in, counselor. Depositions are built out of boxes. That's one of the purposes of them. That is the architecture of the entire system of discovery, to be honest with you, is to intentionally box people in and cut through the fluff and get to what did or did not happen, what evidence we have or don't have. The lawyer then asks whether Bobby authorized Randy to make purchases under $5,000. A truthful and correct answer might be yes and or no. But instead, Bobby says, Randy knew what kind of man I was. Nobody knew what that meant, and it was not an answer to the question. So opposing counsel asks again, and Bobby says, you had to be there. Opposing counsel asks again, Bobby, did you authorize Randy to make any purchases under $5,000? And Bobby answers, it's complicated. Same question for the fourth time and the fifth time. And Bobby just keeps making it more difficult than it needs to be. Define authorized. After 30 minutes, the court reporter had developed the facial expression of someone watching a shopping cart roll slowly toward a parked car. But they can do nothing about it. And then, thank goodness for everybody, Bobby decides this is a good time to make jokes. But this is dangerous because humor is useful in ordinary conversation, perhaps even podcasts. But during testimony, humor can look as evasive, or it can appear arrogant, disrespectful, or downright bizarre when reduced to black words on white paper. Opposing counsel asks, were you angry when Randy left the company? And Bobby says, does a one-legged duck swim in circles? The transcript will not include Bobby's grin. It will simply read, were you angry? Does a one-legged duck swim in circles? Months later, a judge may read this alone in chambers and wonder why the witness refused to behave like a human being. And then comes the most famous deposition mistake. Bobby starts answering questions that nobody has asked. Bobby, did you take the trailer? No, and I certainly did not ever remove the serial number. Nobody had mentioned the serial number or removal of it. Opposing counsel pauses. What happened to the serial number, Bobby? What are you talking about? Bobby looks at his lawyer. His lawyer is looking at the ceiling. A deposition is not the place to prove how smart you are. It is not the place to win every argument. It is not the place to punish opposing counsel. And it is certainly not the place to introduce new crimes into the conversation. Listen, pause, answer truthfully, and shut up. Silence is not a medical emergency. It's actually a pretty effective tactic in interrogation techniques and responses to interrogation techniques, which is what a deposition is. Silence is necessary sometimes in cases like this, and you are allowed to stop speaking when you answer the question. Typically, long pause from somebody doing the questioning, they are waiting for you to volunteer additional information. And so don't fall for that. All right? But again, if you want to screw up your case, do like Bobby did. Talk and not shut up. Think you're funny when you're not. Don't answer the questions. Be evasive and be dishonest. Don't do any of those things. Answer truthfully. Answer only what's asked. And shut up. Those are my witness advices. I am not drinking Mountain Dew today. I am drinking just stone cold milk. And it's quite nice. All right. Step 8. Dress for war. Step 8 is to arrive at court dressed like you are either invading a small country or attending a nightclub opening. And I could literally write a book on things that clients or opposing parties have arrived to the courthouse in. Courts should decide cases based on the facts and law. Human beings, obviously, however, do in fact notice presentation. You do not need an expensive suit. And actually, it even goes for lawyers. I know a number of lawyers who love to spend $3,000 to $5,000 or more on suits, and I guess they just like better-looking gift wrap when they lose. But anyway, that's a whole other topic for another day, I suppose. The whole purpose of your appearance in court or deposition or otherwise is you need to look respectful, clean, organized, and serious. Period. Oftentimes we tell people, dress like you're going to church, Do not dress, in scanty clothes or dirty clothes or anything else. Just dress like you're going to church. All right. Bobby asks his lawyer what he should wear, for example, and the lawyer says business attire, like you're going to church. And Bobby arrives wearing cowboy boots, tactical pants, a black polo shirt with an American flag on the sleeve, and a coiled snake on his chest, and sunglasses resting on the back of his head. His belt contains a flashlight, a folding tool, 2 key rings, a chain to the pocket, and something that may or may not be a compass. It's just hard to tell. He looks prepared to either testify or to go out and locate a missing hiker. The lawyer says, "Where's the jacket we discussed?" And Bobby says, "This is who I am, and I want the jury and people to know who I am." Court is not an identity showcase to a certain extent. It is a legal proceeding. The judge does not need to experience the full range of your personality before the clerk calls the case. Bobby enters the courtroom carrying a large, insulated drink container. The bailiff tells him food and beverages are not allowed, and Bobby says, "Well, it's just water." The bailiff says it cannot come in, and Bobby says, "I have a medical need to remain hydrated." Bobby does not have a medical need. Bobby has a preference, and this becomes an unnecessary argument before the hearing even begins. And this is another way clients damage cases. They fight with courthouse personnel, and they act stupid with people that work there. Now look, I don't understand why people don't understand this. Don't fight with court clerks. Don't fight with court coordinators. Don't fight with security. Don't fight with bailiffs. Just don't. These people are not your legal opponents, and they're not the enemy. There are people who make the courthouse function and run smoothly. Even when it's not running smoothly, they make it run as smoothly as possible. So be polite, be early, turn off your phone, remove your hat, do not sigh loudly, do not react loudly to things that happen or are said in the courtroom, do not shake your head during testimony. Do not whisper, "That is a lie!" The judge can see you. The judge can see everything if they want. And they develop peripheral vision, usually found only in birds of prey, it seems like. They get pretty keen on figuring out what's going on in their courtroom. But the other part of it is, if you argue with the court staff, guess what they do? They go tell the judge or the judge's court staff, and then the judge's court staff tells the judge. It always gets back to the judge. And so the judge knows, okay, this person is trying to put on this great appearance, but they are treating people terribly, and they're jerks to people they don't feel like can help or serve them. And that tells a lot about a person. Be nice. All right? Step 9. Don't interrupt the judge if you want to win your case, but if you want to really screw your case up, aggravate the judge as much as possible and interrupt them whenever conceivable. Because obviously you have to interrupt the judge because your point that you want to share is far too important for anybody to wait anymore. All right, so the hearing begins. Randy's attorney makes an argument. Bobby disagrees and whispers to his lawyer, "You know that ain't true." But it's not actually a whisper. And the lawyer says, "I know." And Bobby whispers, "You better tell the judge that ain't true." And the lawyer says, "Bobby, I will." Bobby waits nearly 2.5 seconds, and he whispers, "You're just sitting there letting him lie." And the lawyer says, "Please stop talking right now." Opposing counsel continues. Bobby shakes his head. The judge notices and tells Bobby, "Sir, please stop reacting and stop speaking unless you're being spoken to." And Bobby says, "I'm sorry, Your Honor, but that's what he's saying is a lie, and that's just not what happened." The courtroom becomes silent, and the judge says, "Bobby, I'm sure you are aware, your attorney is going to have an opportunity to respond to what is being said." And Bobby says, "I understand that, Judge, but obviously there's much more to the story than what this man's saying." And the judge says, "Bobby, do not interrupt again." Bobby says, and before the judge is done speaking, Bobby says, I'm not trying to interrupt, Your Honor, but I just think it's important that the other side of the story gets out because they're not telling everything that happened. And Bobby is literally interrupting while denying that he's interrupting in the first place. This is a rare form of performance art, and it's impressive to watch every now and then. But regardless, Bobby takes the witness stand. His lawyer asks him a question, and Bobby gives a very lengthy answer. His answer even includes some of his genealogy and ancestral careers. Opposing counsel objects, and the judge sustains the objection because it is not relevant to the case. But you know what? Bobby says, but I wasn't finished, Yana. And the judge says, you need to stop talking when I'm talking. Do not interrupt and listen to what I say. Bob looks at the jury, rolls his eyes, and shrugs his shoulders. Don't ever do that. The judge is not your debate opponent. The judge does not need you to explain procedure. The judge does not want your commentary on the ruling. When the judge speaks, you stop and shut your mouth. And then when the judge asks a question, answer it. Specifically, concisely, ideally without profanity. Just answer the question. And when the judge rules, accept the ruling unless your lawyer has a lawful basis to seek reconsideration or preserve an objection. That is not your job, right? That's the lawyer's job. So you just sit there and shut your mouth and hold on. Because the lawyer, your lawyer may and often does disagree with the judge. And here's a shocker. The judge often does disagree with your lawyer, but they also disagree with the other lawyer. They disagree with everybody, and everybody disagrees with everybody. That's kind of the whole purpose of this theater. Right? Not everybody's ever going to agree, but we do the best we can to find out where the truth is and what the truth is. So your lawyer is going to respectfully argue on your behalf. Your lawyer needs to preserve error for appeal and note objections. And so do not roll your eyes so aggressively that they require a separate court reporter. Just be cool. All right. Here's a big one, and a lot of people do this. In fact, my office this week has been hired 3 separate times for trials coming up within the next 2 weeks. Now, number one, that is ungodly expensive for you to do. Number two, I'm going to get into this a little bit more, but I'm never quite sure what people are hoping to accomplish when this happens. So, here we go. Step 10, fire your lawyer before trial. One of the best ways to lose your case. When all else fails and you feel you're not being heard, you must fire your lawyer shortly or immediately before trial. Sometimes, to really be melodramatic, fire your lawyer during trial. I mean, it worked for H.H. Holmes, the famous serial killer. He fired his lawyers and hired them back 3 or 4 times in the course of his final trial. So why not give it a shot? All right? When this happens, usually happens after the lawyer communicates bad news to the client. Good lawyers cannot and will not promise victories. They will evaluate the evidence, they identify weaknesses, they will explain the risk, they will explain the status, they will explain what they think. And clients sometimes mistake honesty for disloyalty. Bobby's lawyer schedules a meeting, and the lawyer explains that several claims remain strong, but the deleted evidence, damaging messages, inconsistent testimony, and social media posts have created a significant risk towards Bobby's case. The lawyer recommends considering some type of settlement. Bobby leans back in his chair and said, "Dag nabbit, Bubba, I hired you to fight for me and to be in my corner." And the lawyer lets out a sigh and says, "I am fighting, Bobby. Doesn't sound like it to me, counselor. My job is to advise you the full spectrum of events and give you advice and my opinion on what you should and should not do." "Exactly whose side are you on, counselor?" This question has ended more attorney-client relationships than probably almost any other. The lawyer is on Bobby's side, and that's why the lawyer is sitting Bobby down and telling him what the problem is and what's in danger. the lawyer would be doing Bobby absolutely no favors by saying, hey, you know what, Bobby? You are the best witness ever. Your courtroom demeanor is perfect. Everything looks fantastic. The 27 threatening messages that you sent gives us an excellent chance, not to mention the conspiracies and the removal of evidence and the hiding of evidence and the trying to coerce people into testify the certain way you want. None of that's really problematic. We can get through that all. Just, we're rolling. So Bobby leaves the meeting angry. That evening, he searches top aggressive lawyer near me. He calls 3 firms. He tells each lawyer, my current attorney is afraid to go to trial, which means, and what he really means is, my current attorney read the evidence and has paid attention to my case. Bobby hires a new lawyer. The new lawyer receives 8 boxes, 4 digital folders, an incomplete chronology, a trial setting, and a client who says, you'll understand everything once you see everything. The new lawyer, however, does not understand everything because nobody understands everything. And Bobby is terrible at explaining what's going on. The case has become a moving cloud of documents, accusations, voice messages, screenshots, text messages, and unexplained random photographs of trailers, trailer hitches, tires, and even some included memes. 2 weeks before trial, Bobby becomes dissatisfied with the new lawyer again. And the new lawyer refuses to call Linda as a witness because Linda did not see anything and is in fact not a witness to anything. So Bobby has the same conversation. I heard you to fight for me, boy. I am fighting, Bobby. It doesn't sound like it. My job is to do the best I can with the evidence in front of me and to do what I can to achieve the goal of winning this case. Whose side are you on anyway, counselor? Bobby fires the second attorney, and a third attorney, and a fourth attorney, and after several continuances to the trial to allow for new counsel, Bobby announces finally to the world and to the courts that he will, in fact, represent himself because nobody is smart enough to be able to take his genius on as a client. There is, in fact, a saying that is attributed to Abraham Lincoln. It says, he says a man, but I'll say person here. A person who represents... Lincoln would be sad that I screwed up his quote. Any man who represents himself has a fool for a client. Bobby considers this elitist propaganda created by the Bar Association. But it's actually true. At trial, Bobby gives an opening statement that lasts 43 minutes. In his opening statement, he attempts to introduce evidence, including screenshots, text messages, and writings without any type of authentication. He asks leading questions on direct examination. He objects to his own witness. He refers to the judge as Sir after being corrected twice. The judge asks Randy, excuse me, Bobby asks Randy, isn't it true that everybody knows exactly what kind of person you are? Opposing counsel objects. The judge sustains and Bobby says, I'll rephrase the question, Your Honor. He does not rephrase. He says the same thing, even louder. Isn't it true that everybody knows exactly what type of person you are? Bobby attempts to introduce Facebook comments supporting his position. The judge excludes them. Bobby says, but these are real people, Judge. The judge says, that's not the issue. Bobby then tries to call his own former attorney as a witness, and at this point, the legal system begins trying to protect itself, according to Bobby. And the downward spiral continues, and I think we all know what happens at the end of this trial. Now, at this point, somebody's probably asking themselves, well, why would anybody do this? Why would they sabotage their own case? And because it's easy to laugh at Bobby, right? Bobby's funny because maybe it's just the accent I use in narrating his speech, but he's funny because he's familiar, because we all know people just like this. Now, granted, most clients and most issues are not this extreme, but many otherwise intelligent people make smaller versions of these same mistakes. And why? Because litigation is emotional. Because people let those emotions control their behavior, because they reach a point where those emotions and that inherently illogical sense that comes with them takes over. A legal case may involve your children, your marriage, your home, your business, your reputation, your freedom, money, and even your future. And so you feel attacked and you feel defensive and you want to prove everybody wrong and show everybody how wrong they in fact are because you've been attacked. You feel misunderstood. You may feel that nobody's listening to you. And you may believe that if you could just tell the judge the whole story, or if people could just hear what the real story was, everything would then make sense. Now, I say all the time that lawyers are basically just professional storytellers, but there are some exceptions, right? There are some differences because litigation is not ordinary storytelling. Courts operate under rules. We have very strict rules that we have to follow and find, and evidence, for example, must be admissible, and there are long checklists and issues that have to happen to make sure that evidence is admissible. Testimony must be relevant. Documents must be authenticated. Deadlines matter, procedure matters, and burden of proof matters. What some people believe to be the strongest evidence of their case is really just the strongest emotional fact. And it's not always the strongest legal fact. The thing that bothers you most about litigation may not be the thing that wins the case, because that is where lawyers and clients can become frustrated with one another. The client says, "You don't understand, he lied to my mother," and the lawyer says, "Nobody cares, because that has nothing to do with this contract." The client thinks the lawyer doesn't care. The lawyer cares very much. But the lawyer is trying to translate pain into proof. The lawyer is trying to make the best story and tell the best story to the jury, and the judge is following all the rules that we talked about. A lawyer must convert a human conflict into causes of action, defenses, elements, evidence, and remedies. And sometimes that process can feel very, very cold. It's not necessarily cold, but it can feel cold because it has to be disciplined. And so a regular story might be able to color outside the lines and do a lot of other things, but the reality is when you're in litigation, that story is bound and metered and controlled. Now, because we have discussed 10 ways to lose a case at this point, let's replace them with some of the ways lawyers try to protect you, right? Now, we've gone through this. Obviously, tell your lawyer everything, including bad facts. If there's something that's bad or scary or whatever else that you don't want to tell anybody, tell your lawyer. Let the lawyer decide what matters and what's going to come out. Number 2 is preserve evidence. Save messages, save emails, photographs, save everything. Don't delete, don't edit, don't crop, don't do any of those things. Evidence does not require your creative direction. It speaks for itself most of the time. Obviously, number 3, stop contacting the other side. Once lawyers are involved, step back and shut up. Don't threaten. Do not negotiate privately. Don't send one final message to prove your point. There never is one final message to prove your point that has ever meant anything or held anything of value. Number 4, don't talk about your case in social media. Assume every post will be printed, enlarged, and displayed in court. And before posting, ask, would I like the judge to read this slowly while they are looking at me? And if the answer is no, don't post it. And even if you don't really care, don't post it. Rule 5, follow your attorney's instructions. When your lawyer asks for documents, provide the documents. When your lawyer gives you a deadline, follow the deadline. When your lawyer asks you to review discovery responses, actually review them. Don't wait until midnight before the deadline and email. Looks good. It did not look good because you didn't read it. Rule 6 is prepare for testimony. Preparation is not memorizing answers, it's understanding the process. You need to listen, you need to pause, you need to tell the truth, and you need to answer the question asked. Do not guess, don't exaggerate, do not volunteer, do not perform. The courtroom is not looking for America's top star. It's just looking for a credible and understandable witness. Rule 7, control your emotions. You're allowed to be angry. You're allowed to be afraid. You're allowed to be nervous. You're allowed to be hurt. You're allowed to be upset. But don't let the opposing party control your behavior. If Randy can make Bobby explode by smiling, Randy owns the remote control to Bobby's credibility. Do not hand your opponent that power. Rule 8 is respect the court. Be early. Dress appropriately. Address the judge properly. Do not interrupt. Do not react visibly. Do not bring an audience of 15 relatives wearing matching shirts. Matching courtroom shirts are literally never helpful. Especially shirts reading, Team Bobby. Rule 9, understand risk. A strong case is not a guaranteed case. There is no such thing as a slam dunk case. I don't care what anybody ever tells you, what you've seen in the movies or on TV. No two cases are alike, and there is no such thing as a slam dunk. But at the same time, a weak case is not always hopeless. Settlement is not surrender. Trial is not automatically courage. The correct decision of what to do, settle or go to trial, depends on the evidence, the law, the cost, the risk, the available remedies, and the client's goals. A lawyer should and will explain all those things to you honestly. Rule 10, don't be an internet lawyer. Let the lawyer be the lawyer. Ask questions, demand communication, understand strategy, participate in decisions, but do not undermine the person you hired to protect you. A legal case requires teamwork. The client brings the facts, the lawyer brings the legal training, courtroom experience, procedure, and strategy. Neither can function well without the other. So, those are the 10 things to do. So let us return to Bobby as he represents himself at trial. He calls his brother Dale as his first witness. Dale, have you known me to be an honest person? Opposing counsel objects to the question. The judge sustains, and Bobby says, okay, Dale, am I honest? Opposing counsel objects again. The judge sustains. Bobby whispers loudly, this is un-effing believable. He then asks Dale whether Randy stole the trailer. Dale says, I did not see him take it. Bobby says, but you know he did. Dale says, that's what you told me. Bobby looks betrayed. Dale was supposed to be on the truth team. Bobby calls Curtis. Curtis testifies that Randy had the authority to make purchases under $5,000. And Bobby asks, did Randy tell you to say that? Curtis says, no, you told me not to say it. And opposing counsel at this point becomes very interested. Bobby decides not to call Linda. This is the best strategic decision he has made in 18 months. But then Bobby himself takes a stand. He tells the jury that he believes in honesty, and opposing counsel approaches with a stack of exhibits. They are the messages, deleted records, Facebook posts, truck video, truth team group chat, deposition transcript, and the text stating, I approved of the purchase. Opposing counsel asks, Mr. Bobby, did you send those messages? And Mr. Bobby says, they're being taken out of context. What context is missing? The situation. What situation? You see where this is going, right? All of it. Did you approve the purchase? Not in the way you're making it sound. How did you approve it? I approved it conditionally. On what condition? That it be a good purchase. Where is that condition written? Anywhere in all this communication. It was understood. By whom? Me. Opposing counsel pauses. So the condition was understood only by you. It's only then that Bobby realized he has wandered into a trap and he attempts to escape. Well, Randy should have known. How? Because he knew me. There it is again, the legal doctrine of he knew what kind of man I was. This doctrine appears in no statute, no reported opinion, no recognizable legal treatise. But it appears to Bobby. And then the questions go to the jury. The jury deliberates. Bobby loses most of his claims. Shockingly. The jury awards Randy damages on a counterclaim, and outside the courthouse, Bobby tells his brother, the system is rigged. The system was not rigged. The system simply read Bobby's messages. Listened to him, and he was his own worst enemy. So look, legal cases are rarely destroyed by one dramatic mistake. They are usually damaged through a series of small choices. And those choices can be the text message sent in anger, a deleted email, exaggerated statements, A missed deadline, social media post, an argument with a witness, an attempt to hide a bad fact, or refusal to listen. The people who perform best in litigation are not necessarily the loudest, angriest, wealthiest, or most confident. They are often the people who remain disciplined. They preserve evidence. They communicate honestly. They prepare. They control their emotions, which is very important. They understand that a courtroom is not a place where volume becomes truth. And they work with their lawyers rather than forcing their lawyers to spend half the case protecting them from themselves. The opposing party is already trying to defeat you. Do not join their legal team against yourself. Do not contact the opposing party. Do not post about the case. Do not delete evidence. Do not surprise your lawyer. Do not bring 47 pages of internet research based on a man named Patriot Dad 1776. Good gravy. Do not coach witnesses through a group chat. Do not treat a deposition like it's open mic night. Don't arrive at court dressed like a tactical bass fishing operative. Don't interrupt the judge. And do not fire 3 attorneys because none of them will tell you that the screenshots are good for your case. Most importantly, don't tell your lawyer that you've already handled it. Because whatever happens after that sentence is going to be much more expensive. All right, this has been another episode of the Associated Podcast. I am Josh Carpenter. Like I said, this podcast is written, hosted, and narrated by me, produced by Todd Cohen, and presented in association with Carpenter and Associates Law Firm right here in Dallas, Texas. Our purpose, as stated, is to educate, guide, and help people understand legal history, the law, courtroom procedure, litigation strategy, and what to do and what not to do when the stakes are high. I hope that was fast enough for you. This episode was created for educational purposes only and entertainment. It is not legal advice, and listening to a podcast does not create an attorney-client relationship on any level. Every case is different, every person is different, every jurisdiction is different. So, do your homework, find the right person, get your story told. And, by the way, every Bobby believes that his situation is different also, and sometimes it is. Usually the screenshots are still going to be coming in, though. So until next time, preserve the evidence, don't be stupid, listen to your lawyer, stay off Facebook, and please never create a group chat called The Truth Team. Until the next episode, I wish you good luck in all you do today, and have an amazing day. All right, take care. Oh, sorry, if you need anything, please call us at 972-455-8700, or we can be found at carplawfirm.com. My email is josh@carplawfirm.com. Have a fantastic day. Goodbye.
Yeah, you know who it is. Hey, don't ask who did it. Check the name, fool. The associates did it, yeah, they rolling deep.